name is Jessica Goldrick and I'm here with Rafe McMahon, and together we are the two partners of McMahon Goldrick Solicitors. This firm specialises and very much enjoys representing and assisting clients who have been affected by life-changing, or also known in the legal world to be called catastrophic injuries.
We exclusively specialise in three categories of injury, and these are catastrophic spinal cord injury, catastrophic brain injury, and catastrophic birth injury. When we say catastrophic, we mean life-changing for the individual. We deal with these injuries whether they arise from either a personal injury, such as a road traffic accident, or a workplace injury, or indeed whether they arise from medical negligence, for example during a surgical procedure or negligent obstetric care.
This video serves as a guide to the parents or guardians of a child who has suffered a birth injury. Typical injuries that lead to birth injury compensation claim are often related to the baby not receiving sufficient oxygen during or just before delivery. This can be caused by inadequate monitoring, failure to diagnose a condition, the mother experiencing complications during the birth, or improper handling of the baby once it's born. A reduction in the supply of oxygen to the brain may cause brain damage or lead to some other form of permanent disability, such as cerebral palsy. If your child has unfortunately suffered from a birth injury and that injury was caused by the negligence in the medical care afforded to the mother and baby, then a case may be brought to receive financial compensation.
We are now broadly going to take you through some of the steps that are involved in bringing a case if indeed your child has suffered from a birth injury. Birth injury claims can be brought by a parent of the child acting as a next friend and up until the child's 18th birthday. Thereafter, the individual has 2 years to bring a birth injury claim in their own right. The person bringing the claim is called the plaintiff. The first step for the solicitor is to take up all of the medical records and scans from the medical practitioners who provided care to the expectant mother and the hospital where the baby was born. When we receive these records, we carry out a thorough review to see what issues there may have been in the care afforded to the mother and baby, to see if there might be a link to the baby's injury to the interpartum events. For example, we will be looking out for the following: evidence of fetal distress in labour, the cord blood pH, the baby's condition at birth, otherwise known as the APGAR score, encephalopathy in the first 72 hours of life, or evidence of hypoxic ischemic injury.
When we engage the appropriate expert, such as an obstetrician or a neonatologist, to thoroughly review the records and scans and prepare an expert report on the standard of care provided by the medical practitioners and whether there was any negligence which led to the baby's injury. Depending on the unique circumstances of the case, we may require a number of reports from experts of varying professions, such as paediatric neurology, radiology, and fetal medicine, before liability and causation can be established. It is important to be aware that a case of this kind cannot be brought without a supportive report from an independent expert that there was negligence in the care provided by the medical practitioners. Once we have obtained a supportive report or reports, we can then begin the process of bringing proceedings in the High Court.
The person or party who allegedly caused the injury is called the defendant. When your proceedings have been issued, the solicitors for the defendant will obtain their own expert reports which comment on the issues of liability and negligence. To help with the investigation, the solicitors for the defendant will request for your solicitor to issue them with a copy of the relevant medical records and any other records in relation to the injury and the treatment received. This process is called discovery.
Broadly, there are 3 categories of reports that your solicitor will obtain for the purpose of building a birth injury case. The first category we already discussed, and they are reports relating to liability and causation. The second category of reports are medical reports. If appropriate, some of these reports may be obtained from the child's treating doctors, for example, the GP, paediatric neurologist, and the rehabilitation consultant. These reports are obtained for the purpose of detailing the child's current condition and future prognosis from a medical perspective.
The third category of reports are what is known as quantum reports, and these are the reports which the solicitor will use for for the purposes of calculating the bulk of the value of the claim for compensation. Your solicitor will instruct a number of experts to assess the child's current needs and what their needs will look like moving into the future. Experts under this category can include physios, occupational therapists, care consultants, housing experts, assistive technology experts, vocational experts, psychologists, and rehab consultants. Those experts will make a number of recommendations to help the child live a more independent life moving into the future. For example, the housing expert may advise in relation to the costs of building a home to make it fully accessible. The nursing expert will make recommendations in respect of the number of private care hours that they may require. The occupational therapist will advise in respect of the equipment needs and their associated costs, again moving into the future. The vocational assessor will ascertain, to the extent that it is possible, what the likely future loss of earnings will be. And finally, an actuary will review all of these quantum reports to calculate the total value of those future recommendations.
The costs that have been built up to date will be included in the claim. For example, the hours put in by loved ones caring for you will be valued, in addition to the loss of earnings and any monies that you may have put into making adaptations to your home. The solicitors for the defendant will typically obtain like-for-like quantum reports, which means that for every type of expert your solicitor sends to see the infant, the defendant will arrange for an expert of the same profession.
The defendant's experts will also ascertain the child's past and future needs. However, the value of their recommendations is often much lower than the value of the recommendations made by your own experts, and this is where negotiation will come into play. As you can probably tell by now, obtaining the appropriate expert reports is crucial. Your solicitors must know who the leading experts are and be able to competently instruct them with all of the relevant details and medical records, so that you can ultimately obtain meaningful compensation and adequate compensation to help your child live a more independent life.
For most people, pregnancy and giving birth is one of the happiest times of their lives. However, if things go wrong, it can be a very traumatic time for parents. Birth injury claims involving children who are injured during the course of labour, delivery, and in the neonatal period are some of the most tragic, emotional and distressing types of medical negligence cases that come before the courts. It is therefore important that you engage solicitors who have a full understanding of the nature of these injuries and the impact that they have, both from the medical side of things and in terms of how they can affect the whole family.
Your solicitor will hire barristers on your behalf. In a catastrophic birth injury case, you will have a junior barrister and possibly one or two senior barristers. Your solicitor and barristers will work together as your legal team. Your barrister will advocate for you in court, prepare some of the legal documents that must be filed in a case such as this, and provide legal opinion on whether or not you have a good legal case. They will also advise your solicitor in respect of steps to take to overcome certain issues that may crop up. And finally, your barrister will be the person who negotiates a settlement if your case does not go to trial. Therefore, it is equally as important for your solicitor to hire a barrister on your behalf who is not only experienced in handling personal injury and medical negligence cases, but also have an in-depth experience of dealing with complex, catastrophic birth injury claims.
The vast majority of cases end up settling outside of the courtroom. However, there is never a guarantee that a case will not go to trial. If a case proceeds to trial, the judge will hear evidence from each party and each of the parties' expert witnesses. The judge will then decide whether or not to make an award in the child's favour. If there is a successful outcome, there is usually a payment made directly to the parent or parents for retrospective care, which is the additional care that was provided because of the injury, and also for items paid for by the parents up to the date of settlement. If a case is settled or if an award is made by a judge, typically the State Claims Agency will make the payment in the case of medical negligence cases relating to care provided in public hospitals.
If you have been successful with your case for compensation, then you may receive a lump sum payment or an interim settlement or periodic payments. Although it should be said the courts are currently not disposed to making periodic payments, we will always engage an expert, however, to secure his view on this very point. If you have full mental capacity and if you are over the age of 18, you can then spend this money as to how you see fit. If the claimant is under the age of 18, then the funds are typically lodged in the High Court until the child turns 18. In the meantime, the child's next of friend, typically the parent, will be permitted to take out monies to cover the child's expenses and to make big purchases, such as for housing and equipment, or indeed care. Our clients often use the funds to build a fully accessible home, purchase an accessible car, pay for private care hours and private medical treatments, and purchase equipment to help them live a more independent life.
Advice should be secured from a tax expert to ring-fence any monies that are secured in the settlement, so that tax is not paid on income that is generated by investments. We always say that no matter what is recovered, it is never enough for what has occurred, but the lump sum helps to give security and capital to launch a new venture on the back of any confidence that has come with the case being at an end.
Finally, we are now going to go through some of the first steps that you should take if you are considering taking legal action in respect of a catastrophic birth injury suffered by a child. If you are aged 18 years or over, you only have 2 years to bring a claim from the date of your 18th birthday. There are some limited exceptions to this. If you are inquiring on behalf of a child who is below the age of 18, then the time window is much more extensive. The statutory time limit of 2 years only starts from when the child turns 18. The child's next of friend, as we say, typically the parent, has the ability to bring a claim on their behalf at any point in time if they were under the age of 18. One of the first things that you should do is make contact with the solicitor, who can then advise whether or not you may have a claim on behalf of your child.
Another early step that you should take is to write down all of the details that you can recall of the circumstance of the birth and the care provided during the pregnancy. Now, this can be a particularly difficult exercise to do after experiencing such a traumatic event, but it will be of tremendous benefit to your potential new solicitor, and it will assist them with the process of taking your formal instructions. Crucial details such as what happened on the day of the delivery, for example, and what medical services you immediately received should be noted. The sooner you write down those details, the better.
Another step you can take to possibly expedite the early stages of the investigation is to obtain all of your medical records, radiology, and reports from the hospitals you attended, as well as those from your GP. Information on how to obtain those records will be available on the hospital's website.
We are now going to talk about how we in McMahon Goldrick Solicitors approach these types of claims. We understand that clients who have suffered from a catastrophic birth injury have very specific needs and concerns. We purposely maintain a very low number of files so that each file has individual attention. We have over 60 years combined experience, and we only deal with catastrophic injuries. So the specialist nature of our office allows us to gently glide over hurdles that others may, with the best will in the world, procrastinate about. Over the years, we have established professional connections with the top medics and expert witnesses who are involved with these types of cases. And our clients are informed in real time of any developments, and they get their case heard as soon as possible, but without taking any shortcuts.
Without ever losing sight of the sensitivity of the injury, we go about our work in that empathetic and honest way, completely aware of how difficult and anxious having a catastrophic injury is. Clients regularly confide in us and share private matters with us. We respect that. What we want to do is to walk in the client's shoes with them. Please, as always, email or telephone us with any queries on a non-committal basis. Thank you for watching this video.